allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
So we will open a meeting with public comment. Is there any public comment?
I don't know if
Yes,
you're
sir.
going to do it today. Brandon told me there was an issue with one of my claims in regards to my photographer. And so it was discussed on Monday, but no one reached out to me, so I figured I'd come over and see what the issue was.
This is, there was written on your request to follow the claims policy, so I don't know what that.
So we have a claims policy and we've been following it for quite some time. Basically, with a claim that's pretty boilerplate, it's on the bottom there, we sign it, signed by two, goes through the claims process, it's put on the claims approval form, and then we vote to, as it says, pay the approved claim. So in order for a claim to be on that list, it has to be already approved. So that's why that is coming to the meeting like we do with all claims. So claims are either signed in the accounting office. If there's an issue we need to discuss, they come here to a meeting and we discuss it. Depending on who it's for, what it's for, if it involves HIPAA, personal privacy rights, then it's done in a closed door. Either way, it makes it to the report, and any privacy information is redacted. So with this one, there's two things. One is, we set up, it was my idea to set up the 43.8 account. And the idea was that it could be, the money in that account is $50,000. It's from PILT, and there's two caveats. It's for the sheriff to spend in a way that he sees fit that honors Mason Moore. Two caveats. One, PILT has to be fully funded. If it's not, then we need to look at, where PILT needs to go. And two, the way that money is to be spent is not on anything that would be of self-promotion. What the motion specified was vehicles, overtime, tasers, weapons, bullets, that kind of thing. So we've had to address in the past year, maybe year and a half, a number of claims that have been for pencils that say support your local sheriff, or something like that. Challenge coins, and in this case, a professional photographer from Fort Benton. We had photos taken, and we did it with a phone, and it cost us nothing. If you want to do photos in your department, I would say let's go ahead and let department heads do that, but we should not be bringing in somebody from Fort Benton. We do have photographers here. We should not be spending $500, especially when 3 weeks ago I received another call from a citizen who was called 911. She was on the highway. The call was not answered, and one of the things she asked me about is the complaint from the Board of Health meeting where calls were not being answered because there's not enough money in the budget for gas. We made the budget whole. There was a surplus beyond what the sheriff's office budget was this year, and there was still upset that there wasn't enough for deputies. I think it is a waste to be spending $500 for pictures from a photographer in Fort Benton. So, just following the claims policy, those are my issues, and if you want, we can put it on the agenda or talk about it, whatever you guys want to do. But if we do this, if we allow this for this department, every department gets an open door to spend $500 on pictures from a photographer brought in from out of town. So.
We've been doing pictures in that office since Rich Thompson was sheriff. And it used to be Audrey out of Helena that came down and charged a ton of money for it. And commissioners paid for the frame that was done back in 2014 that we currently use today, which costs $660 to get done to Ben Franklin. So you're right, the Mason Moore count in that motion that was made, I still have it. said that the Mason Moore account was to be used at the discretion of the sheriff as he or she felt fit. And I did reached out to Commissioner Folkford before I even made an agreement with Eric from Bird Images to do this, because I think it's right for the people of this community and this county to be able to walk into my office and see who works for them. And this isn't something that's new. We've done it year after year. Well, we haven't done it since 2016. And so everybody on my board is no longer, for the most part, employed in my agency. So I needed to update it. And I did reach out and ask for a blessing before I even got into the agreement with it, because I didn't want to have this hassle. And I got the email right here where he said, absolutely.
Well, I
People
guess,
should know.
I mean, you're right, when you did ask me, and my opinion is, I agree with you. I think that it's important for the people in this community to know who serves them, especially in our law enforcement. And that was the reason I feel that is correct, and I signed that. I approved it. So where it goes from here, that's up to the other two commissioners.
Well,
And that's where I stand. I want everybody to know that.
this isn't a new practice. This is something that's done in every sheriff's office in the state of Montana. Has a professional photographer come in and take pictures of their staff. And those are the same pictures that are utilized when Mason was killed. That's the same one that's on the wall or in a memorial back in DC. That's a picture. Yeah, if you want to take a mugshot photo off a phone, feel free. But these are professional people that serve the citizens of this state, in this county, and this community. And a picture that represents them respectively in their attire, I don't think is too much to ask for. And I think the people of this county are going to agree that they want to be able to know who works for them. And this is, like I said, this is nothing new. We've been doing it since Rich Thompson was sheriff. And every time I turn around, no matter what I ask for, I have to come down here and do this. Because somebody says, well, it's not what we want to do. Well, this is past practice. It's been done. Go back to when Brenda was here. Go back when Rich was here. These things have been done over and over. And now, just because I'm sheriff and people, we don't necessarily agree with things, now we want to make it an issue. And that's the frustrating part. So, you know, I don't understand what the issues are. You're right, my budget's whole, and whoever said that they didn't get a response on a traffic complaint, let me be honest with you. The highway is actually the highway patrol's jurisdiction, not mine. And so there's no constitutional or statutory requirement to go out and chase people up and down the highway on traffic complaints. You should probably call Colonel Butler and tell him to get some troopers down here. That's not my forte anyways, but we try to do the best we can with what we have. It's kind of like everything else that goes on. And I haven't come down here and complained about my deputies. I haven't filled the position. I haven't said a word about it. I've had issues with my dispatch center. I've got that fixed. I think we've got the issues in the detention center fixed, besides the fact is we have no inmates. But everything else you haven't heard from me on. So that's where I stand.
This is not a question of not honoring the people that work for you, not calling them professional. Like I said, we've done pictures that are of very good quality without spending $500 for them. If your budget was one that has not been so contentious, if there were extra money in your budget, then it wouldn't be an issue. But it has been a subject of extreme contention the last couple of years. There are complaints from the public, and I think we have to be responsible to them. And
Well, I haven't been getting the complaints.
Well,
if
I
there's
don't
a
know
complaint
about that,
the
Lynn,
office of the
but
sheriff,
the
it should be
other-
directed to the office of the sheriff.
excuse me, thank you. The other point is you didn't get clearance from the commission. You got clearance from one commissioner who did not have authority to speak on behalf of the full commission. I am simply following our claims process, and I have that responsibility
Well,
as a
let me
commissioner.
go back to your procurement policy. I don't even need to come down here and ask you for permission for anything under $5,000. So if you want to talk policy, let's talk all of it. It's $500. I don't need to ask your permission. And that's set in your own policy that you put out. You said anything under $5,000, I didn't need to come talk to you about. I could tell you about it if it was under $5,000 or $1,500, but this is 500. So technically, I don't need to ask your permission in the first place. I did it out of courtesy. That's your policy. So which
This
one do you
is-
want to stand by?
When
Laura?
I would like civility.
Well,
Immediately.
so would
Thank you.
I would like the fact that every time I put in a claim, just because you don't agree with it, I have to come down here and justify it. Even though your policy says that I don't necessarily need to. Because under the statute and the way the law is once you finalize my budget, you no longer have authority on how it's spent.
That is
You know
not the
that as
case,
well as
and
I do,
you know
because
it. I am going to speak to this. This is not the procurement policy. That is for capital. That is not for every willy-nilly thing you want to buy.
That's not willy-nilly.
This is self-promotion.
This has been
and
done
it's-
time again. You've been commissioner for the last 10, 11 years.
Yep.
You have signed how many claims from Brenda Ludwig for pictures?
This is not personal, Lynn.
The hell
There
it's
are-
not, Laura.
Okay, you can have your own opinion. You may not have your own facts.
You denied my challenge coins. You argued with me on the
That was
medals.
self-promotion.
That's not self-promotion. We've been doing that when Brenda was sheriff. That's the same thing. You argue with me about the medals to give my staff for saving people's lives.
No, we have passed those because.
I had
of
to come
what
down here and argue with you about it because
We have a responsibility to ask questions and to know what it is that county money, the citizens' money, is being spent on. You do not have to agree with that. That is our charge by law. It is in MCA,
you know
and
what?
I'm going to continue to do my
Yeah,
job, Lynn.
I
period.
notice you hold everybody else to the same standard.
That's exactly what I'm trying to do
Yeah.
here.
Yeah, you're right.
Yeah, thank you very much.
Because, we won't get into the other things that are way out of whack, right? You want to talk about that, or just keep beating on the guy that brings in the most revenue of this county, and you guys want to jam me up on having pictures taken? But every sheriff in the state of Montana has pictures taken. Hell, Sheriff Gookin and Sheriff Slaughter up in Great Falls just paid to have videos done for recruitment of their agency by the same guy. Had videos done. I'm pretty sure that their commissioners didn't give them a bad time about it, right? Because I'm sure that was cheap to have a video made to recruit employees, right? You guys are trying to hold me to a different stand when everybody else just says yes. And it's the past practices that you've done. In the past, it's the same thing. The only difference is who the sheriff is. And the fact is I'm a contentious person, and I rub you guys the wrong way. That's what it comes down to. You know it, and I know it. And I've been trying to come and play nice with you guys. I come to Daryl's elected officials and department head meetings, and I'm pleasant, I'm civil in those, unless I miss something. I had all my staff come in for your driver's training, even though that cost me a ton of money for a training for people who don't drive county cars. But mandatory for all employees. Right? Do what you're gonna do.
I guess the only thing that I would agree with Daryl that I think this is something that you definitely need to have it done. I think that people deserve to have that right to know who their deputies are when they come into the office. The only issue that I really have is that did you talk to Kelly Morris by any chance?
I don't even know who Kelly Morris is.
Well, he's probably about the best photographer in the county, and he's an excellent photographer. I mean, the issue that I have is that no one local was contacted for it. I mean,
And the reason why is because Eric was at our MSPOA convention taking our photos there. And I'll be honest with you, you go out and get your senior photos done, and what do you spend, $250, $300 for a session? Right, for one person. I got 28 people that gotta be photographed. So if we're spending $250 on one session for a senior, I didn't think that having 28 people photographed was gonna be, $500 was unreasonable.
I don't doubt that you didn't get a good deal on it, but I just think that if you, I guess if you didn't know Kelly Morris existed, then I guess that's I'm probably pretty sure he would have given you pretty much the same deal.
So we had a gal do some photos for us, and they didn't turn out well. And so, it was $200, and I was like, you know what, it's not $200 worth of good photographs. So, yeah, there's that one gal here that I knew about. And my other person that did them last time, it was my ex-daughter-in-law, and she moved back to Georgia after her divorce, so it didn't do much good, so. But
I want to clear up one thing that you said, and it's not true. One of the things I said in bringing this up is, absolutely, I support the pictures. The citizens absolutely have a right to know who is working for them, either in the sheriff's department or the rest of the county. There is absolutely no reason, though, why, one, it couldn't have gone local. Ask the question. Google it. We have several photographers that are professional. And then two, if you've got a really, really, really tight budget, $500 can be spent on overtime, weapons, tasers, vests, and you can get good quality pictures without that kind of cost. So if you would like to follow the process that we already have, and we can go through this and change it, but this is the process we have now, then, let's see. If there is disagreement between the commissioners regarding a claim, it will be placed on the agenda. The commission will vote. The majority decision shall be final.
So we need to place this on the agenda for next week?
Mm-hmm.
Okay. So we'll get this on the agenda then. Thank you.
He's supposed to be here on Friday.
Excuse me?
He's here Friday,
Okay.
and he was expecting payment when he got here.
Okay, let's see, did you have a COS, Bernadette?
Hello there, I do. I assume, are you Mr. Kirk?
I am.
I'm Nicole, nice to meet you.
Nice to meet you.
The Stephen Kirk family transfer, and Bernadette so nicely here, thank you so much. So, per our process, you all received this 12-ish days ago. This is the Kirk family transfer. Mr. Kirk is here. He is gifting Tract B2 to his daughter. This is on Old Town Road, southern end of Broadwater County. I have the family transfer documents here if you'd like to peruse them.
I did review this when you sent it to us, Nicole, and this does appear to fit the intent of the family transfer. This is just a personal question. Is your daughter moving back? Or moving here?
No, she's actually just finishing up with her second bout with cancer, and they had to sell her house to pay all her doctor bills, so
Oh,
I'm
I'm
trying to help them
sorry.
out by giving them some land to build a little house on that they can, got someplace to live.
Absolutely. I'm so sorry to hear that.
She's tough, she's staying with it, so appreciate it.
Good for her.
Yeah.
Well, you got my vote on this.
Oh, thank you.
Yeah.
Is there any other discussion?
No, if you're asking for that, I will move to support this family transfer as it does appear to fit the priorities or the requirements of family transfer in MCA.
No, second.
Motion's been made and second to approve the Kirk family land transfer. Any further discussion? All in favor?
Aye.
Aye.
Opposed, same. Motion carries. Do we have a signature on this thing?
I'm not sure if there's a signature on that or not. I'm sorry, this is still, I'm learning my way through this.
We don't normally have one, do we, or do we?
You could sign, there's a blank line on the back page. You could sign it and then print underneath.
And I can amend that to say commissioner's signature on that too.
Probably not a bad idea.
Yeah.
Yeah.
I think that was the intent of those lines, and I'm sorry that was just assumed and not explicitly spelled out, so I will make that change moving forward. Thank you so very much.
Good luck to your daughter.
Thank
And
you.
are you going to record these today too? No, these are signed. Yeah, correct. Okay, so you're good. You're all done. And I know it's not time yet, but I will start passing out documents. Totally
I'd
correct.
like this to 5 is first.
You should have all received your yellow books, or no, this one is a gray book, I'm sorry. Yellow is the next one. This is the findings of fact and order report. Sorry.
Thank you for the
Is that you?
books.
Yeah,
I
you're
appreciate
welcome.
getting those early
Yeah,
like that.
makes the process much better.
For the record, I will be abstaining for the vote on this subdivision.
I have an extra if you care for it.
Thank you.
You're welcome. And I will begin reading whenever you tell me you are ready.
I am ready.
Alright, so this is the findings of fact and order for Lake Vista, Lot 5, Major Subdivision. Preliminary plat is dated August 1st, 2019. The applicant is EBJ LLC out of Bozeman, and the applicant's representative is Bernadette Swenson of Townsend, Montana. This subdivision is located off of Alaska Trail, approximately 4 miles northwest of the city of Townsend. I should mention, since this is a major subdivision, a public hearing was held by the planning board on September 18th, 2019. We did not have any written or public comment. This property was previously subdivided and is known as Lake Vista Minor Subdivision. The developer intends to create 7 lots from an existing 20.08 acre parcel. Lots range in size from 2.35 to 3.61 acres. Parkland is shown on the preliminary plat in the location of an existing natural drainage. These lots are being submitted for review as residential lots. The required preliminary review fee of $3,075 has been paid. All of the lots proposed are subject to DEQ review. Draft proposed covenants are included in the preliminary plat application. Review is performed pursuant to the Montana Subdivision and Plating Act, Section 76.3101 through 76.3614 Montana Codes Annotated, and the Broadwater County Subdivision Regulations. The proposed preliminary plat, Lake Vista Lot 5 Major Subdivision, as submitted by the applicant, together with the required supplementary plans and information, appear to satisfy the requirements of these regulations and comply with the Broadwater County Growth Policy Plan dated July 2007. A vicinity map as well as a preliminary plat is provided in the preliminary plat application. No rock outcroppings or the presence of bedrock have been identified on the property. The nearest open water body is the Canyon Ferry Lake Reservoir, which is approximately 0.4 miles to the east. The proposed development is not in an area subject to flood hazard. Each lot will be served by an individual well. Excuse me. DEQ will review all of the lots for septic and well locations. Well log data for 7 wells in the vicinity are located on the preliminary plat application as item number 14. Average depth of the wells is 112 feet deep and static water level averages 57 feet. Yield averages 37 gallons per minute. Individual wastewater treatment systems are proposed for all 7 lots. These lots will be reviewed by the Montana Department of Environmental Quality for the adequacy and impact of the wastewater treatments or the wastewater systems on groundwater quality. DEQ will issue a determination of non-significant impacts and a certificate of subdivision approval, which must be presented to the county for recordation of the final plat. Lot owners will be responsible for disposal of their own solid waste. Subdivision residents will have the option of hiring an independent contractor to pick up their solid waste or transport it themselves to the Broadwater County Transfer Station, Winston Canister Site, or the Townsend Canister Site. There is an existing drainage that traverses the property in a northeasterly to southwesterly direction. The drainage is designated as an 80-foot wide drainage easement and is being dedicated as parkland by this subdivision plat. All roadway drainage structures will be designed in accordance with regulations as required by Broadwater County and DEQ. The current use of this parcel is vacant subdivision land. According to the preliminary plat application, this property would not be considered prime farmland even if it were irrigated. The subdivision should not have an effect on agricultural productivity since it is not currently utilized for any agricultural purposes and is part of an existing approved subdivision. The responsibility to maintain boundary fences will be the individual landowners. The developer will be required to control any noxious weeds until the property is turned over to the subsequent landowners. An environmental assessment is not required since this proposed development lies within an area covered by the Broadwater County Growth Policy Plan. No falls, slides, or slumps or adverse soil, rock, mud, or snow have been identified on the property. No rock outcroppings have been identified either. The property is located within the intermountain seismic belt that extends through western Montana and frequently produces small earthquakes and has previously developed some major earthquakes. Property damage and risk can be minimized with construction techniques and earthquake planning. There are no marsh, shrub, or forest lands located on the property. There are no trees or vegetation cover. Existing vegetation consists of light native grasses and some prickly pear cactus. No critical plant species have been identified. Existing vegetation will only be disturbed for necessary construction of roads, driveways, utilities, and structures. Any construction disturbance will be reseeded with an approved grass seed mix. A weed management plan is in the process of being developed with assistance by the Broadwater County Weed Coordinator to control and prevent the growth of noxious weeds. The developer will be responsible for adhering to the weed management plan until all lots are sold or the responsibility is turned over to a homeowners association. Wildlife such as antelope, deer, upland game birds, other small birds, snakes, rabbits, fox, and coyote occasionally utilize the proposed subdivision. However, the use is infrequent due to the lack of cover in prime feeding areas, as well as the close proximity to nearby residential development and a busy highway. Therefore, the impacts to wildlife should be minimal. A letter was sent to the Montana Historical Society on June 14, 2007, for the previous subdivision, Lake Vista Subsequent Minor, to determine if there are any known historical, cultural, or archaeological sites which may be affected by the proposed development. A response letter is enclosed in the preliminary plat application as item number 33, which states there have been no previously recorded sites within the designated search locale. Access to all lots will be off of the existing internal subdivision road, Alaska Trail, via US Highway 287. Alaska Trail is an approved subdivision road, and the access onto US Highway 287 has been previously approved as well. The entire road length of Alaska Trail, as proposed for this development, will be 3,090 feet. However, the Broadwater County subdivision regulations state the maximum length for a dead-end road is 1,500 feet. The developer proposes to leave the existing cul-de-sac in place at its current location of 1,366 feet in length and install a second cul-de-sac at the end of the additional 1,728 feet. A variance request for the deviation from the Broadwater County subdivision regulations for maximum length of dead-end roads is included in the preliminary plat application and must be approved by the Broadwater County Commissioners prior to receiving preliminary plat approval from the Commissioners. Utility service will be provided by Northwestern Energy. Natural gas service is not currently available. Electricity is currently available to Lake Vista Lot 4-5. Each lot will have a 15-foot wide utility easement located on the perimeter boundaries. A transmission line with an unidentified easement width bisects the subdivision on the lot lines between Lot 5-3 and Lot 5-2. The proposed subdivision is in the Broadwater County Rural Fire District jurisdiction. The distance from the nearest fire station, the City of Townsend Fire Hall, to the subdivision is approximately 4 miles. According to a letter addressed to the Broadwater County Rural Fire Department dated July 25, 2019, the developer is requesting to pay the per lot cash in lieu of water supply fee of $1,000 per lot, payable at the time of sale and closing on each lot. The Broadwater County Rural Fire District Chief agreed to this and approved the fire plan on August 15, 2019. The Broadwater County Sheriff's Department will provide law enforcement services. The Sheriff's Department is located approximately 4 miles from the proposed subdivision. An email from the Sheriff states he does not have any major concerns regarding law enforcement, but he believes the Fire Chief might have some concerns regarding fire suppression and available water in the area. The Broadwater Health Center, also located in Townsend, will provide both ambulance and emergency medical services to the subdivision residents. The proposed subdivision is served by the Townsend schools. This subdivision could potentially produce 10 to 11 students according to figures obtained from the Broadwater County Growth Policy Plan. The potential for new students from this development could have an impact on existing bus routes, which may need to be altered once the subdivision is at full build-out. Lands to the north, east, and west of this property are part of a subdivision. Lands to the south are residential. Since the property is bordered on the east by the heavily traveled US Highway 287 and to the west lies the Burlington Northern Santa Fe Railroad, these could potentially pose a serious risk to the safety of the subdivision residents, especially to children and domestic animals. These risks can be mitigated by proper setbacks, fencing, and homeowner awareness. Since this is a major subdivision, the parkland dedication requirement is required for this proposed development. The developer proposes to dedicate 1.43 acres of parkland within an 80-foot drainage easement. Although this parkland could not necessarily be developed, it could be utilized as a walking path to connect this development to adjacent lands to the south. It is hereby ordered that the preliminary plat for the Lake Vista Lot 5 major subdivision is approved, subject to the conditions listed below. Final plat approval shall be contingent upon completion and compliance with these conditions. Plans for sewage treatment and water supply shall be submitted to the Montana Department, number 1. Plans for the sewage treatment and water supply shall be submitted to the Montana Department of Environmental Quality for review and approval. The certificate of subdivision approval shall be filed with the final plat. Number 2, a stormwater drainage plan shall be submitted to DEQ for review and recommendation. Number 3, the applicant will be required to submit the preliminary and final plat drawings in electronic format to Broadwater County in ArcGIS, AutoCAD, or MicroStation format. Additional materials may be requested by the county in electronic format to facilitate review of application materials. Number 4, plans for the location and installation of individual mailboxes shall be reviewed and approved by the United States Postal Service prior to installation. Number 5, the extension of Alaska Trail must be designed in accordance with the Broadwater County Subdivision Road Standards and stamped by a professional engineer. A letter from the PE shall be provided to the county stating that the road and any improvements have been constructed in accordance with the approved plans and specifications, and that he or she has completed an inspection of the road and any improvements. Number 6, prior to filing the final plat, the applicant shall adequately fund or improve a proportionate share of Alaska Trail from its intersection with US Highway 287 to the first cul-de-sac. The road improvements would have to be constructed to a minimum of the Broadwater County Subdivision Road Standards and must be certified as meeting county subdivision road standards by a registered engineer. Number 7, the applicant and the Fire Protection Authority having jurisdiction shall use their best efforts to draft a fire protection plan specifically for this subdivision in accordance with Broadwater County subdivision regulations. The plan shall be equally acceptable to the FPHJ, the applicant, and the county governing authority. The plan shall adequately address the fire risk analysis, all findings of fact, and appropriate mitigation measures. In the event the parties are unable to come to agreement by the final plat submittal, the applicant shall become eligible to provide the per lot cash in lieu fee for water supply as may be defined in the Broadwater County subdivision regulations in effect at the time of submittal. Number 8, prior to any development and/or soil disturbance, a weed management plan for the proposed development shall be submitted to the county weed district for review and approval. Number 9, the book and page reference to the restrictive covenant filed with the county clerk and recorder shall be indicated on the face of the final plat. In addition, restrictive covenants revocable or alterable only with the consent of the Board of County Commissioners shall be placed upon the property and shall provide for the following. A, per the subdivision application, all lots shall be used for residential purposes only. B, notification of the potential health risk from radon concentrations and that such risk can be evaluated through soil tests and mitigated through radon abatement techniques incorporated into structures. C, a notification that all dwelling units within the subdivision should be constructed to specifications which meet or exceed equivalent provisions in the applicable state building code for this seismic zone, which is Zone 3. D, notification of the potential degradation of existing emergency services due to the potential for growth in a rural area. E, any additional replacement or relocated utility lines shall be installed underground in accordance with county subdivision regulations unless otherwise determined by the utility provided. F, a no-access restriction along US Highway 287 with the exception of the approach onto Highway 287 for the internal access roads. G, any exterior lighting shall be directed downward to minimize visibility beyond the property lines. H, notification of the presence of agricultural operations in the vicinity. I, a waiver of the right to protest to join a special district for the purpose of providing community water and/or wastewater treatment system improvements and/or maintenance. J, a restrictive covenant binding the landowner, any heirs, successors, and assigns, and all future owners of the property within the subdivision agreeing therein to hold Broadwater County harmless and indemnify Broadwater County from all claims, demands, obligations, suits, causes of action, damages, and liability, including the county's costs and attorney's fees arising in any manner whatsoever out of or relating to the existence, use, operation, repair, and/or maintenance of the following. Sub-item 1, earthquake fault zone and any seismic activity, and number 2, water availability. K, each lot shall be maintained in a clean, attractive, and weed-free manner. Noxious weeds must be pulled, sprayed, or cut prior to seed maturity. L, a prohibition of the storage of foods, garbage, or continuous feeding of domestic pets outdoors or other activities that creates an attractive nuisance for wildlife species. Hay or alfalfa storage and feeding are not prohibited where livestock are permitted. M, lots shall only allow for livestock if a small acreage livestock management plan is reviewed and approved by the county extension agent and submitted to the county. Each lot owner shall be required to create and adhere to their own livestock management plan. N, all cats and dogs must be restrained, penned, or otherwise under the control of their owner at all times. Number 10, prior to filing the final plat, the following improvements shall be installed or otherwise guaranteed. A, roads. B, any necessary improvements required by the stormwater drainage plan, weed management plan, fire protection plan, or approach permits. And C, utilities abutting and available to each lot, electrical and telephone shall be underground. If said improvements are not installed prior to final plat, then the applicant shall enter into a written subdivision improvements agreement with Broadwater County guaranteeing the construction and installation of such improvements and shall provide an acceptable financial security guarantee in accordance with county subdivision regulations appendix E. Number 11, prior to filing the final plat, the applicant shall A, provide proof that all taxes and special assessments assessed and levied on the property are paid for the current tax year, including any past delinquencies, and B, provide documentation, an abstract of title or platting certificate showing that the applicant is the lawful owner of the property with the apparent authority to subdivide the same. showing the names of lien holders or claimants of record in the written consent to the subdivision by the owners of the land, if other than the applicant, and any lien holders or claimants of record against the land. The applicant is financially responsible for actual outside engineering, consulting, professional and/or contracted service fees, etc., at the sole discretion of the county for additional review and/or final plat approval of the proposed subdivision. Preliminary plat approval of the Lake Vista Lot 5 major subdivision shall be enforced for 3 calendar years. At the end of this period, the governing body may, at the request of the subdivider, extend its approval for a mutually agreed upon period of time. Any mutually agreed upon extension must be in writing and dated and signed by the members of the governing body and the subdivider or subdivider's agent. The governing body may issue more than one extension. A party as defined by 763625 MCA who is aggrieved by a decision of the governing body may, within 30 days after this decision, appeal to the Broadwater County District Court. I do want to point out Commission Required Covenant A. This is new. This is the first time you're seeing this. This came from Terry Depew. That this should be a Commission Required Covenant that we should be including on all subdivisions from here on out. If an applicant applies for, or I'm sorry, on their application, if they state it's for residential or commercial, the best way to enforce that is through Commission Required Covenants.
So if it were also, say, 50-50 residential and commercial, then this would say will be used for 50% residential, 50% commercial?
That is correct, yes.
Okay.
So that covenant, that Commission Required Covenant will always mimic what is written in their application. So it can be fluid. It may change depending on the application.
I like that. I think that's a good,
I
good
do too.
suggestion.
And that came from some discussion that we actually had at the planning board level on this next subdivision coming up, but so I don't want to get off track, but there are options sometimes. You know, we don't have building codes, we don't have building inspectors, we don't have zoning. So how does a landowner know when they go to purchase it? You know, having a realtor sit on our planning board was very beneficial, has always been beneficial, because we can see it from the landowner or the purchaser's perspective. How does a realtor or a potential landowner know what that property can be used for without digging back through the subdivision file? So this is a very handy tool for potential future landowners and realtors as well.
Fantastic.
Yeah. So it was a great discussion that we had, and so then I put the question to Tara, and she said, yes, this is how you should address this. So. And one last thing too, I know you probably still want to have discussion on it, but I just want to be sure that you vote on the variance request before the preliminary plat.
And I did notice that the fire district did send a letter that the variance request would satisfy their needs. That is signed by Ed.
You referenced item 10, and it doesn't correspond with 10 in here, so there's...
It doesn't, I'm sorry.
Where would that be?
The variance request,
Yeah.
I should probably make that change in the report card too. I'm sorry.
34.
Okay.
It should also be in the front leaf, isn't it? I guess that's just the plan. The fire plan, so it also has the information.
I don't see in the findings of the fact report where it says number 10. Can you tell me where you saw that? Just so I want to make the change to make it correct.
Well, it was on his report. It says we will support the
Oh, on
variances
Ed,
as
okay.
stated in number 10,
Oh,
That was,
and accept the proposal as stated in number 9. So what's he
that's
talking?
items 9 and 10
Yeah.
of the fire plan.
so
okay.
not of
Oh,
this, but of his, okay,
okay.
good.
I guess that's where I got confused, okay. Okay, thank you.
No, I make mistakes, and I
Okay,
appreciate being able to correct those when I can,
yeah,
if I could.
that makes sense, thank you. Okay,
So with the approval of Ed Schindel, I move that we grant the variance as requested and required for subdivision preliminary plat.
Is there a second?
No, second.
Motion been made and seconded to grant the variance for the fire plan for the preliminary plat. Any further discussion? All in favor?
Aye.
Opposed?
Question.
Motion carries.
Question.
Yes, sir.
Just real quick, is the variance exclusive to the fire plan, or did it go further than that? Have not seen or heard about
It's only for the fire plan for the size of the cul-de-sac, is it not?
Do you want me to address that?
Yes.
Okay, so the variance request, our subdivision regulations allow for a maximum dead-end road, so any road that ends at either a hammerhead or a cul-de-sac of 1,500 feet.
that. Okay.
With the extension of this road, and the reason for that is for emergency services, so that the fire trucks have room to maneuver and get out, so they're not going in and being stuck. So the variance request is not necessarily for the fire plan, it's for the length of the road to basically go against the subdivision regulations. The commissioners do have the latitude to to grant that variance. The fact that Fire Chief Ed Schindel said he has no issues with it just makes this variance request that more solid. Because the reason for it being in the subdivision regulations is for fire protection. Does that answer your question?
Thank you.
Okay. I didn't wear the right shoes for standing for an hour, I'm sorry.
Okay, when we're done with these, I have 2 questions for you, just so you don't scoot out of the room too fast.
Okay.
Thanks.
Or run really fast.
Right.
Thank you for the warning.
I think a warning is always good.
Can I add something else to this while you're perusing? This parkland, in our subdivisions, I am a huge fan of interconnectivity between developments. I always think of children going to visit their neighbors, anybody going to visit their neighbors for that matter, but that's what I generally think of. So I think that this parkland is beautiful in the sense that, yes, it can't be used for developed parkland, and this was not, I did not propose this came from the developer's representative. I just think it's a brilliant idea to turn this drainage into parkland. So if this is ever developed, these children, people, anyone, don't have to funnel out to the highway to visit their neighbor. So say this lot here is visiting over here, their only option would be to drive to go over here, even though it's literally out their back door, unless you're trespassing and walking through people's yard. I wish we had done this with Grandview Manor. I wish that we had some interconnectivity with Grandview Manor now with, that size of development. So I think this is brilliant, because this parkland, yes, it can't be used for a developed park. You can't, put playground equipment or anything in it. You can walk it, you can connect to potential development area. Not that anything is proposed here, and not that it will be, but anyway, I just wanted to add that.
So my question is, we're going through an issue on the south end of the county where there's only one way in, one way out. And that's what this is turning into, one way in, one way out. So if you end up with a grass fire or something, or you've got no way for those people to get out.
That's correct. I mean, other than that road or to drive across lots.
The ingress and egress is only required though from major, or, this is a major,
This is a major.
right. So is that a requirement of our covenants?
Subdivision regulations no longer require two.
Okay,
It's a good idea.
right. And something to consider when we update our subdivision regs. But right now, it's not in regs, so it's not something we can require.
That's correct.
Okay.
So this developer, when he did the front two, did he buy tanks to put into Grandview? He bought tanks to put into the Grandview water supply system for
I
fire
believe
suppression.
so, but that's a long time
Yes,
ago.
he did.
Did he? Thank you.
But there's still no access from this subdivision other than to go all the way out to the road and go all the way back into Grandview. So is there any way that he can get access to Grandview in the future on the next phases, or?
Not unless there's already a dedicated easement in Grandview. You can't add that to Grandview now because of the lot owners there bought with no easement
The
there.
road is
no road
inside,
through.
you know, it's a loop road, but the lots are on the outside in Grandview as opposed to the road being. Does that make sense?
It would be a great idea, and I think on a different project, we tried to do that, or we questioned and looked into it, but you can't add that to them now because all of those landowners bought without that additional traffic being added to their subdivision. Does that make sense?
So if the ground to the south is subdivided, can we require him to provide access to the south and those people to provide access from the north? If and when those subdivisions come in, can we require him to establish an easement to go to the south in case that ground to the south does get developed? Because if it doesn't, we're gonna end up with another road that's just a dead end. It's gonna be 1.5 miles to the railroad tracks, and we've got no way for people to get out of there.
You can
For
do that.
either this subdivision, or if the one to the south gets developed.
You have done that in the past, not this commission necessarily, but the commissioners have done that in the past. Wheatland Meadows, off of Wheatland Road, Morning Sky, also off of Wheatland Road. They have, we call them, what did we call them? Half streets, not half streets. Yes, half streets is actually, I think that's the term. To where they're not constructed. They are easements shown, you know, at appropriate locations on that plat. So you can make that request on this, you can add that, and you still have another, I scheduled this with you, so you have another week to review it too. I also want to let you know that you don't have to make a decision today. But you can require that there is an easement, a 60-foot easement there. Doesn't have to be built by the developer. And the way that we worded that in those subdivisions, and I can pull the language, you know, I won't get it now, but I can send it to you. So any future development has to build the road in this subdivision. So I don't know if I'm making myself clear, but, you know, so this development, there could be a 60-foot easement in this subdivision. They don't have to construct it. If this is ever developed, they are required to construct and align their road to match this.
So are they required to construct the road? Can both of them just have a 60-foot easement without constructor, or one of them has to construct the road?
Someone has to construct it.
So if the person to the south builds there and we require them to, then does he have to build the road through this person's lot also?
Yes, they have to
So
build.
they would be,
Yes, and that actually came from Susan Swimley when she was the Mako land use attorney.
it wouldn't be a shared expense on each subdivision,
No.
since each subdivision gains on it.
This subdivision then wouldn't have to pay for it, and you would have, you know, once they've been given final approval, you don't have well, even preliminary approval, you can add more conditions. But this potential new development would have to align their street to match, using this point, at any point, to match with that easement, and the condition of approval would be to also construct this road. And they would know that going into it, you know, they would know that at the time of pre-application meeting. So they could determine if they want to proceed. So it wouldn't be a surprise to them. And that's why I'm saying, you know, with Grandview, it sure would have been nice had we planned that, because seeing the way that it's starting to develop out there, and we all know the traffic out there.
Right.
To drive out, to turn, to go to your neighbors, that's scary.
Yeah.
And you're seeing more and more people driving along the fence line.
Right.
Which probably, I'm not going to say whether that's legal or not, but, you know, people walking along the fence line.
So the process for us to request that or impose that, I guess my first question is it a request or is it we require this? Would it go then back to the landowner and their agent to come back to us and say okay or no? Does it have to be done between now and the deadline, which is next week? How would that work?
So you would put it as a condition of approval that a 60-foot access, and I'll come up with better language, I'll pull what we have already, but basically this 60-foot easement for a half street would have to be put in place somewhere to connect the lands to the south. So they could use some discretion. That would be a condition of approval. They would have that time from when they receive, or if they receive preliminary plat approval, to final approval, to put that easement on their final plat. So then you would get a chance to actually see it when it came back for final plat approval. Does that answer your question?
It does very well, thank you. I was just writing down everything you were saying.
But I would want to use the same language that we used for Wheatland Meadows and Morning Sky. I think it's important to keep regurgitating the same conditions when they're appropriate.
Again, equity, what you do for one, you do for all. Yeah, I like that idea. I don't know where you guys are at. And I think it makes sense for future planning. We don't know what the future holds, but like you said, if only we had done it before. This time we have an opportunity to not have the if only, but to actually do it.
Exactly.
Yeah.
Yeah, I think that's a really good idea.
Bernard, if he had to take that out of there, I assume he would take it out of 2 lots, or maybe if he took it out of that, you can't take it out of the very end one, because that's your parklands comes into your drainage comes across there, right?
You can take it out of the very end lot. I mean, you know, obviously it wouldn't be appropriate to put it in here, but this being the very end lot, you could take it out at the very end, because this is also a subdivision lot right here at the very end.
It doesn't make any of those lots unbuildable for any reason, does it, to do that?
No, it wouldn't push them below an acre. This end lot is 2.66 acres.
Okay.
So if you wanted to make that condition that you pick where that 60-foot easement goes, you can do that as well.
Yeah, I would like to be a little flexible because of terrain purposes, whatever that, you know, or he might want to hold it like right along the power line, since you've got a power line there.
Is that what that is a power line there?
Yes.
In the middle? Okay. I drove out there and I think that's what I remember seeing.
Yeah, so that might be a good future road, you know, right there along the power line. Or he may want it on the very back line, if lot 1 was ever developed back there.
I would like the idea of flexibility. This is their subdivision. We can put in the requirement, but I think it's right that they determine where it would be.
Yeah, and the terrain would be the biggest issue. I mean, you
Yeah.
want
The only
to
thing-
say where it was a really bad gully or something.
It's true. The only thing I would like is for it to not go on 5-1, just because 4-5, there's already a homeowner living there, and we held the public hearing, sent them the preliminary plat. I think that could adversely affect lot 4-5.
Because they've already purchased without that being there.
Correct. And it could negatively impact them. You
Sure.
know, we don't know what this is going to look like in 5 years or 20 years, or what's going to happen out there. Anyway, I would just like to say that because they did not provide public comment. I had a casual conversation with them, not at work, but So, you know, they did not provide comment on the record, they didn't have an issue with it. I feel if there's a road there, they probably would have an issue with it,
Yeah,
as would most people. So, you know, my only thought would be, I like the idea of the power line because you can't build under it anyway, to move it somewhere
But there's also
west.
restrictions on the, do you know what the restrictions on the power line easement is? I know they can't build direct, or you can't run a road directly underneath it, but I believe you can run it
Adjacent.
off to the
Okay.
side of that, adjacent to that easement.
Right.
Okay.
Mhm.
And that has to
And
be,
you wouldn't want it, because it's an overhead power line, so
Yeah.
you wouldn't want it right under there anyways, or you'd be swerving around poles.
so you don't need it, does it need to be, you called it a half street, so does it only need to be a 30-foot easement, or does it need to be a 60-foot?
60 foot, just unconstructed.
Okay.
But I, not that I want to prolong this any longer, but with that being said, I would like to have some time to pull that condition from Wheatland Meadows and Morning Sky, so potentially to wait until your next meeting, Monday, which is only
a couple
a
days.
couple days away. I can have that ready for you. I know it's not on your agenda, however, but you haven't sent your agenda yet, maybe?
That
Or
is
finalized?
correct.
Okay,
It has been emailed, but,
Right.
you know, if we have kind of a process that it doesn't get sent out officially till noon,
Till
so
noon,
we've got some
right.
time.
so you have some time,
Yeah.
27 minutes
Right.
worth of time.
So, and
But,
it
so I'm not
might-
trying to rush you, and I'm sorry, I don't mean to interrupt either, I just want that to be said, that I don't know that condition off the top of my head.
Yeah. Yeah, we could just ask Michelle to hold off till we get the details,
Okay.
and then add it. But I'm good with waiting till next week, at the request of our community development director, based on the discussion regarding the half street.
Yeah.
That's good with you guys?
Yep.
And I think, again, that's a good discussion. I think that it's always good to see different perspective. Obviously, you know, we're learning from our past mistakes. We're always going to be learning. We didn't realize it was a mistake at the time with Mountain Vista Estates. You know, now we have to straighten that out. It just makes better developments in the future for us. So I appreciate this discussion, and I think that's a good idea, because that is not something we talked about at the planning board. But the planning board has not been involved with Mountain Vista Estates recently, like you have, so.
Right. More brains is better than one.
Exactly, yeah.
Yeah.
Okay, we'll move on. to
Moving on quickly, right?
Four Springs minor subdivision.
So this is your yellow book.
Yeah, I rotate colors, but both of these ended up yellow.
No, Lake Vista was great, you were good. Yeah, I said yellow, I was wrong. I've got yellow on the brain. So this is Four Springs, this is a minor subdivision. Get you your reports here.
Thank you.
You're very welcome. There you are. One for you. And I have an extra. This works out great today.
That's awesome.
Great crowd.
Thank you.
Hey, Nicole,
Yes, ma'am.
would you do me a favor and just
Absolutely.
run up and ask Michelle to hold off on the agenda till she hears from us?
Absolutely.
Thank you, I just want to be on the safe
You want-
side.
I can do
Are
that
you sure?
while
You already know what's in here, I guess,
Thank
don't you? Thank you, Bernadette. Okay, so this is the, are you ready for me to start? I guess I should ask.
I am.
Okay. Findings of fact in order for Four Springs Estates minor subdivision preliminary plat dated January 23, 2019. So the date of application was January 22nd, 2019, and the review period officially ended March 29th, 2019. However, you notice I purposely put that strike through on there. A 120 working day extension was requested by the developer's representative on April 20th, 2019 to address access questions and concerns. So the actual review period ends October 9th, 2019. The applicant is Justin Cox and Heidi Ide out of Belgrade, Montana. The applicant's representative is Bernadette Swenson of Townsend. The proposed subdivision is located off of Silos Road, approximately 7.5 miles northwest of the city of Townsend. Excuse me. The developers intend to create 5 lots from an existing 15-acre parcel. The minimum lot size proposed is 2.49 acres, and the maximum lot size proposed is 5 acres. The required preliminary review fee of $2,000 and the weed inspection fee of $200 have both been paid. All lots proposed are subject to DEQ review. No homeowners association is proposed at this time. And although no existing covenants exist for this property, proposed covenants are included in the preliminary plat application as item number 13. Review is performed pursuant to Montana Subdivision and Plating Act, Section 76.3.101 through 76.3.614, Montana Codes Annotated, and the Broadwater County Subdivision Regulations. The proposed preliminary plat, Four Springs Estates Minor Subdivision, as submitted by the applicants together with the required supplementary plans and information, appear to satisfy the requirements of these regulations and comply with the Broadwater County Growth Policy Plan dated July 2007. A vicinity map as well as a preliminary plat is provided in the preliminary plat application. No rock outcroppings or the presence of bedrock have been identified on the property. The nearest open water body is the Canyon Ferry Lake Reservoir, which is approximately 1 mile to the east. The proposed development is not in an area subject to flood hazard. Each lot will be served by an individual well. Well logs in this area show an acceptable water source at a depth of 400 to 430 feet with flow rates of 20 to 30 gallons per minute. DEQ will review the lots for well locations. Individual wastewater treatment systems are proposed for all 5 lots. The typical soils in the proposed subdivision are identified as Radersburg Very Cobbly Loam 2 to 5% slopes. The Radersburg series consists of deep, well-drained soils formed in gravelly and cobbly old alluvium. Permeability is moderate and the available moisture capacity is low. These soils are considered suitable for on-site wastewater treatment systems. The soils information and proposed wastewater treatment systems will be reviewed by the Montana Department of Environmental Quality for the adequacy and impact of the wastewater treatment systems on groundwater quality. DEQ will issue a determination of non-significant impacts in a certificate of subdivision approval, which must be presented to the county for recordation of the final plat. Lot owners will be responsible for disposal of their own solid waste. Subdivision residents will have the option of hiring an independent contractor to pick up their solid waste or transport it themselves to the Broadwater County Transfer Station, Winston Canister Site, or the Townsend Canister Site. There are no existing drainages on the proposed subdivision property, and since no new roads are proposed, no roadway drainages will be constructed. The current use of this property is vacant subdivision land. This property is not considered prime farmland, even if it were irrigated. Therefore, the proposed subdivision should not have an effect on agricultural productivity, since it's not currently utilized for agricultural purposes. The responsibility to maintain boundary fences will be the individual landowners. The developer will be required to control any noxious weeds until the property is turned over to the subsequent landowners. Since this is a first minor subdivision, environmental assessment is not required. No fall slides or sumps or adverse soil, rock, mud, or snow have been identified on the property. No rock outcroppings have been identified either. The property is located within the Intermountain Seismic Belt that extends through western Montana and frequently produces small earthquakes and has previously developed some major earthquakes. Property damage and risk can be minimized with construction techniques and earthquake planning. There are no marsh, shrub, or forest lands located on the property. There are no trees or vegetation cover. Existing vegetation consists of light native grasses and some prickly pear cactus. No critical plant species have been identified. Existing vegetation will only be disturbed for necessary construction of driveways, utilities, and structures. Any construction disturbance will be reseeded with an approved grass seed mix. A weed management plan is in the process of being developed with assistance by the Broadwater County Weed Coordinator to control and prevent the growth of noxious weeds. Wildlife such as antelope, deer, and upland game birds, other small birds, snakes, rabbits, fox, and coyote occasionally utilize the proposed subdivision. However, the use is infrequent due to the lack of cover and prime feeding areas, as well as the close proximity to nearby residential development and a busy highway. Therefore, the impacts to wildlife should be minimal. A letter was sent to the Montana Historical Society on January 17, 2019 to determine if there are any known historical, cultural, or archaeological sites which may be affected by the proposed development. To date, a response has not yet been received. Access to 3 to 4 of the lots will be off of Silos Road, which is a county road traversing the south boundary of the proposed subdivision. Access to 1 to 2 lots will be off of Paydirt Lane, which is not a county road, but rather a subdivision road, and it does have an existing RID in place for the maintenance of the road. Tract 4A is a corner lot which will have access off of either Silos Road or Paydirt Lane. The developer will be responsible for the proportionate share of improvements to the subdivision road, Paydirt Lane. Utility service will be provided by Northwestern Energy. Natural gas service is not currently available. The proposed subdivision is in the Broadwater County Rural Fire District jurisdiction. The distance from the City of Townsend Fire Hall to the subdivision is approximately 7.5 miles. The distance from the Winston Fire Hall to the subdivision is approximately 5.5 miles. According to a letter addressed to the Broadwater County Rural Fire Department dated January 17th, 2019, the developer is proposing a fire mitigation plan that does not include the cash in lieu of water supply fee. To date, a response from the fire department has not been received. The Broadwater County Sheriff's Department will provide law enforcement services. The Sheriff's Department is located approximately 7.5 miles from the proposed subdivision. The Broadwater Health Center, also located in Townsend, will provide both ambulance and emergency medical services to the subdivision residents. The proposed subdivision is served by the Townsend schools. The subdivision could account for potentially 8 students according to figures obtained from the Broadwater County Growth Policy Plan. The potential for new students from this development could have an impact on existing bus routes, which may need to be altered once the subdivision is at full build-out. Lands to the north and south of this property are agricultural, lands to the east and west are residential subdivision. Since the property is bordered on the south by the heavily traveled Silas Road, and nearby to the west lies the also heavily traveled U.S. Highway 287, these could potentially pose a serious risk to safety of the subdivision residents, especially to children and domestic animals. These risks can be mitigated by proper fencing and homeowner awareness. Since this is a minor subdivision, no parkland dedication is required pursuant to 763609 MCA. It's hereby ordered that the preliminary plat for the Four Springs Estates minor subdivision is approved subject to the conditions listed below. Final plat approval shall be contingent upon completion and compliance with these conditions. Number 1, plans for sewage treatment and water supply shall be submitted to the Montana Department of Environmental Quality for review and approval. Number 2, the stormwater drainage plan shall be submitted to DEQ for review and recommendation. Number 3, priority to development, driveway application, and approach permit shall be requested from the County Road Department for the shared driveway only. Number 4, the shared driveway for Tract 1A and Tract 2A must be constructed prior to final plat approval. Number 5, information on the driveway length to Tracts 1A and Tract 2A shall be provided to Broadwater County Planning Office. Driveways 500 feet or greater shall be designed meeting Broadwater County subdivision regulations, and a turnaround or hammerhead T turnaround shall be provided for emergency vehicles with a 3-point turnaround ability. Number 6, the applicant shall contribute 2/50ths of the cost to upgrade the existing road, Pay Dirt Lane, to Broadwater County subdivision road standards for number 1 local road. It shall be required that they obtain a current estimate. Number 7, the applicant will be required to submit the preliminary and final plat drawings in electronic format to Broadwater County in ArcGIS, AutoCAD, or MicroStation format. Additional materials may be requested by the county in electronic format to facilitate review of application materials. Number 8, plans for the location and installation of individual mailboxes shall be reviewed and approved by the U.S. Postal Service prior to installation. Number 9, the applicant and the Fire Protection Authority having jurisdiction shall use their best efforts to draft a fire protection plan specifically for this subdivision in accordance with the Broadwater County subdivision regulations. The plan shall be equally acceptable to the FPHJ, the applicant, and the county governing authority. The plan shall adequately address the fire risk analysis, all findings of fact, and appropriate mitigation measures. In the event the parties are unable to come to agreement by the final plat submittal, the applicant shall become eligible to provide the per lot cash in lieu fee for water supply as may be defined in the Broadwater County subdivision regulations in effect at the time of submittal. Number 10, priority to development and or soil disturbance, the weed management plan for the proposed development shall be submitted to the county weed district for review and approval. Number 11, the book and page reference to the restrictive covenants filed with the county clerk and recorder shall be indicated on the face of the final plat. In addition, restrictive covenants revocable or alterable only with the consent of the Board of County Commissioners shall be placed upon the property and shall provide for the following. A, per the subdivision application, all lots shall be used for residential purposes only. B, notification of the potential health risk from radon concentrations, and that such risk can be evaluated through soil tests and mitigated through radon abatement techniques incorporated into structures. C, a notification that each driveway access for individual lots will require an approved driveway application and approach permit prior to installation of a private driveway on the county road, Silos Road. D, a notification that all dwelling units within the subdivision should be constructed to specifications which meet or exceed equivalent provisions in the applicable state building code for this seismic zone, which is Zone 3. E, notification of the potential degradation of existing emergency services due to the potential for growth in a rural area. F, any additional replacement or relocated utility lines shall be installed underground in accordance with county subdivision regulations unless otherwise determined by the utility provided. G, any exterior lighting shall be directed downward to minimize visibility beyond the property lines. H, notification of the presence of agricultural operations in the vicinity. I, a waiver of the right to protest to join a special district for the purpose of providing community water and or wastewater treatment system improvements and or maintenance. J, a restrictive covenant binding the landowner, any heirs, successors, and assigns, and all future owners of the property within the subdivision agreeing therein to hold Broadwater County harmless and indemnify Broadwater County from all claims, demands, obligations, suits, causes of action, damages, and liability, including the county's costs and attorney's fees arising in any manner whatsoever out of or relating to the existence, use, operation, repair, and or maintenance of the following. Subitem 1, earthquake fault zone and any seismic activity, and number 2, water availability. K, each lot shall be maintained in a clean, attractive, and weed-free manner. Noxious weeds must be pulled, sprayed, or cut prior to seed maturity. L, a prohibition of the storage of foods, garbage, or continuous feeding of domestic pets outdoors, or other activities that creates an attractive nuisance for wildlife species. Hay or alfalfa storage and feeding are not prohibited where livestock are permitted. M, lots shall only allow for livestock if the small acreage livestock management plan is reviewed and approved by the county extension agent and submitted to the county. Each lot owner shall be required to create and adhere to their own livestock management plan. N, all cats and dogs must be restrained, penned, or otherwise under the control of their owner at all times. And O, address numbers shall be clearly marked at the driveway entrance to each lot and be easily identified from the road. Number 12, prior to filing the final plat, the following improvements shall be installed or otherwise guaranteed. A, any necessary improvements required by the stormwater drainage plan, weed management plan, fire protection plan, or approach permits. And B, utilities abutting and available to each lot. Electrical and telephone shall be underground unless otherwise determined. If said improvements are not installed prior to final plat, then the applicant shall enter into a written subdivision improvements agreement with Broadwater County guaranteeing the construction and installation of such improvements and shall provide an acceptable financial security guarantee in accordance with County Subdivision Regulations Appendix E. Number 13, prior to filing the final plat, the applicant shall A, provide proof that all taxes and special assessments assessed and levied on the property are paid for the current tax year, including any past delinquencies. And B, provide documentation, an abstract of title or platting certificate showing that the applicant is the lawful owner of the property with the apparent authority to subdivide the same, showing the names of lien holders or claimants of record and the written consent to the subdivision by the owners of the land if other than the applicant and any lien holders or claimants of record against the land. The applicant is financially responsible for actual outside engineering, consulting, professional and/or contracted service fees, etc., at the sole discretion of the county for additional review and/or final plat approval of the proposed subdivision. Preliminary plat approval of Four Springs Estates minor subdivision shall be enforced for 3 calendar years. At the end of this period, the governing body may, at the request of the subdivider, extend its approval for a mutually agreed upon period of time. Any mutually agreed upon extension must be in writing and dated and signed by the members of the governing body and the subdivider or subdivider's agent. The governing body may issue more than one extension. A party is defined by 76.3.625 MCA, who has agreed to by decision of the governing body, may, within 30 days after this decision, appeal to the Broadwater County District Court.
So the shared driveway, Nicole, that is in our regs as they now stand, correct?
Correct, yeah.
Okay,
Cannot be used for more than 2.
all right, and it's used for 2.
That's the intent. Correct. And the county has some controls over that through addressing, currently me in my department. If, I don't know the tract number.
It
I know
is
Commissioner
2A?
Delger had a question on that, sorry. Look
Yeah,
here,
I have some
tract
questions
5A.
on the effects of road. I don't know if they're numbered correctly.
Oh, okay.
So it says access to 3 and 4, or lots, let's see, access to 3 and 4 of the lots will be off Silos Road.
So full disclosure, I wrote this staff report for the planning board in February with all of the extensions. So I saw that when I was reading through it.
And then access lots 1 and 2 will be off Pater.
Yes, 1 to 2 lots, not actually lot number.
No, that's not the lot number.
Yes,
Okay.
yeah,
Okay.
I get it, when I was reading it, I
Yeah.
kind of stumbled over that
Okay,
too,
that's where I
because
got
I was
mixed up,
a
yeah.
little, but it was, not, those are not showing lots 1 and 2, it's 1 to 2 lots.
1 to 2 lots, okay.
Because this tract 4A could potentially come off of Silos Road. So, you know, obviously 3A has no other option but to come off of Pater.
Right.
So in this 11A, per the subdivision application, all lots shall be used for residential purposes only.
Correct.
But when you go in this book, there's a whole bunch of ifs, ands, or buts in here about the declarant still owning lots and being able to change lot 1A to a commercial lot.
Correct, and that is the developer's proposed covenants. So you have the, at this table, you have the ability to make that a condition, that they amend their proposed covenant. So that's not a commission required covenant, that's not a covenant that the county is imposing on them. This is coming from the developer, that's their proposed covenant. I would strongly suggest that you make a condition, one of your conditions of approval, that they amend their covenants to eliminate that.
To eliminate
Language.
the commercial portion of it.
Why?
Because they cannot be used for commercial. Their application was for residential purposes only. So the way that Commissioner Delger is reading it, and the way that it's proposed, the way I'm hearing it, the owner of the land has the ability to change it, which is contradictory to the commission-required covenants, which states it must be used for residential purposes only, based on the application.
That's how I read it.
So, yeah, I read it that way too, but it looks like a good lot for commercial to me. It does not look like a good residential lot. So if this were proposed as a commercial lot, in the first place, would that still be following the same process, or would our regs require something different for that?
So if this were proposed, and the planning board, I had discussions with Bernadette about this, for tract 1A, 2B, and I think you can lend some more, as far as that approach onto Highway 287. I'll turn it over to you in a minute if you want to talk about that, the reason for that. If tract 1A, I mean, it looks and acts like a commercial lot, you know, that the Silos Bar and Restaurant is kind of nestled right there
Right.
in Highway 287. The developers didn't want to propose it as commercial. They would have to construct that driveway to a county subdivision road standard, or gain access from Highway 287, which had its limitations. So, I fully agree. The only way, if you grant preliminary plat approval to this today with these conditions, the only way for tract 1A to become a commercial lot would, for the landowner, not the developer, but whomever owned the land, if it happened to be the developer, to bring it back through subdivision review.
Because it sounds like they're trying to evade commercial subdivision requirements.
They don't want to build the road.
Right.
Yes.
But with their language, after this is approved, they could then go ahead and make it commercial and avoid that.
They couldn't if you
Oh.
keep that commission-required covenant A in there,
Exactly.
because that's stronger than their covenants, but it's very misleading to any future owners. If you were to buy this lot and say you wanted to put a commercial building there, you're reading through the owner's covenants. The commission covenants say, they're contradictory, I guess is what I'm saying. Even though yours is stronger, yours has more teeth, I think it should be eliminated from their covenants, just to eliminate any confusion.
I agree because of the way this is being done, but I think they would be smarter to just make it commercial and spend the money to do it right. That's just my opinion, has no bearing on my decision, but I do see this as an evasion based on their language.
The planning board felt very strongly that same way. We had to rely on regulations in the law, and I know that, you know, you commissioners are very good at upholding the law. That's partly why this drug on so long, from January, I believe, or, you know, went to the planning board in February, and here we are in October, you know, with these extensions. Yeah, it looks and acts like a commercial lot. However, we cannot force someone to build a road because our subdivision regulations allow for a shared driveway for two lots. It's plain and simple. So we simply don't have the authority to force them to build that road,
So the
to
shared
make that commercial.
driveway
But
is
we
for
don't have to approve
one,
the shared driveway.
It's in the regulations. It's in the subdivision regulations.
and it's for 1A and 2A, not for 5A and 2A.
Correct, correct.
I had misread that, thank you.
Yes, 1A and 2A.
So
Okay.
how are you gonna stop 5A from using the shared driveway? Because that's part of 5A's property.
So we can't build a wall and force them to not use it. So that's what I was talking about with this addressing. When tract 5A comes in, currently to me, to my office, but whomever happens to be there, comes in to request an address, I have to know, or whomever is assigning the address has to know that they can't have an address off of this driveway. Their driveway has to be somewhere east of that. Which, again, you know, that's,
It could be
tricky.
right next door.
it could be right
And
next
then
door,
they could have a
but
wide one.
they do have to have approval from currently Public Works Director for the driveway approach, because the Silos is a county road, so there is some driveway spacing issues. You know, in a perfect world, we could force them, you know, or make them build that as a road. I can't find the authority to say that.
Well, the issue is that if you put a shared driveway in right there, and then you turn around and put another driveway into that other lot, and then you've got all the traffic coming down Silos Road, but you've got the people coming out of the Silos Junction Bar, that's a disaster waiting to happen on that road. And it says right in here, a heavily traveled Silos Road.
And I think we
So
have,
simply by avoiding not building a road, you're putting the public in danger, because you've got two, you
you could have three, because tract 4A could also
and
come
the
up
other
from
thing
here.
that could happen is that person could put that driveway in there, and then as soon as they get inside their property, they go right back over there, build their house back in the northeast corner and go down that driveway. You know, because they don't wanna build a road, and if you're gonna make, if by what they say in here with all this ifs, ands, or buts about making that thing commercial, you're not gonna get an access off 287 right there, because that road's already built and there's no turn lane there.
And they did propose that, that was part of, this 120-day extension, they were trying to work with MDT, and I'll let Bernadette explain that, she knows it in more detail than I do of why that doesn't work. If you wanna explain that?
Well, and number one, that any of the driveways coming off of Silos Road will have to be approved, the location and the construction, by the Public Works Director. So they can't, you know, put two right next to each other just to make a wide one or anything. That will be dictated by the county of where those driveways, the other driveway goes, for driveway spacing, et cetera. Yeah, and then this came up with, well, what if it's sold, what if it's used commercially? And again, the covenants reflect, as this was originally submitted last January. And the landowner and I have had conversations after all this whole process with the commission-required covenant of residential use only. The covenants are being amended, because that will come out. But they tried to get, there is an existing access right at the edge of the property, right at the north entrance, that also access the Silos grounds, an existing approach. And they got permission, they could use that approach, but they could only have a right in and right out because of no turn lane. They would have to put in a pork chop meridian, medium, and overhead lights, and anyways, it was not feasible for a one-lot deal. Their main, and I can't speak for them and they're not here, but we had a lot of conversations on whether making this a commercial parcel because it has that look. The landowner, because of the different requirements at DEQ, depending what the commercial use is, there's totally different DEQ requirements, whether it's a restaurant, gas station, who knows, whatever. And so anyways, the landowner decided that she would prefer it come back to the commission or to the county for commercial use, depending on if it was sold for a commercial use and what the requirements of that commercial use would be able to be reviewed by the county and DEQ. They couldn't make any guess as to what might be used in the future there. So they felt it was in their best interest to just do them residential. If someone is interested in it as a commercial lot, then they would go through the process with the county with a specific commercial use in mind.
Well, that makes sense, thank you.
So let me ask this question, just say if it does come back to us as a commercial lot, then they would be required to make that a county road? That
A subdivision
that shared
road.
driveway?
A subdivision road, not a county road. Build it to Broadwater County subdivision road standards.
Okay.
Sorry, I just wanted to make that clear.
Yes, and that would be a requirement.
Built
That
to
would-
county
I'm
standards.
just thinking, say it, okay, it's whatever, it is a restaurant or whatever it happens to be. All of a sudden, you're gonna have all this traffic on that road. Is that gonna be sufficient to just be a subdivision road accessing a commercial piece of property?
Yes. And also, just for the record, Broadwater County road standards, as in roads that are owned and may be maintained by the county, are identical to Broadwater County subdivision road standards. They're the same. The only difference is Broadwater County subdivision roads are not owned or cannot be maintained by the county unless they have an RID in place. So it's the same road standard. It would be built to a number 1 local road, which is a 24-foot surface, 6 inches of base, 3 inches of top. So it would be built to that standard.
And 60-foot wide.
I'm sorry, yeah, and then 4-foot borrow pits, but a 60-foot easement.
And per the sheriff's department and for this, if this came up, the driveway is a 60-foot easement and it is dedicated to public use so that landowners are forewarned right now at the beginning.
Smart.
And Wynn preferred that as far, so he didn't have any shared driveway issues with landowners in the future, if it was dedicated to the public. But this is kind of like we were speaking before on easements that, you know, could be used for public uses in the future. If we put it on the plat now, then it can be used in the future without, you know, landowners being surprised with it later.
And new question for you, if I may. There's no response from the fire district regarding a fire mitigation plan that does not include the cash in lieu of water supply fee. Can you expand on that?
Yes. So the fire requirement letter is number 26 in
And
your
a different,
packet.
I interject, a different letter was sent. There should be in your front of your packets responses from the fire department and all. I think I had them that delivered them August 12th. At least on mine I do, or August 14th. I delivered packets to the planning board meeting. And it could have been that.
Under, I have it in my file.
And the fire department has signed off and they are paying $1,000 per lot.
Okay, all right.
And I do have a copy of that if you'd like to see it.
Perfect. Thank you very much.
And then come with
You guys want to see that?
right?
Yeah. it should be in that.
Oh, I did miss, I see it right there.
Okay,
Yep, I do have it.
And I do see that you have A again in the commission required subdivision covenants. So nicely done.
So if someone comes in here and buys lot track 1A and they decide they wanna make that commercial, then does that road, does that 30-foot shared driveway, does that need to become a 60-foot? Do they need to come back in and make that a 60-foot right away?
Well, it is already a 60-foot right of way.
What's that?
It just may not be in there for it was-
Right. It may not have, that change may not.
So it has
be
been changed
reflected
to
in
a
there.
60-foot
But
right?
this, yes, this is a 60-foot.
Okay.
Okay. Because that does say 30 on the,
In your book?
No.
Yes. Yeah, probably through this process, but yeah, it is, this will be the preliminary plan.
And is that cul-de-sac big enough for emergency vehicles, to fire trucks and stuff to turn around in?
What is the radius, 50 feet, it appears, yes. That's what our regulations call for.
So
And again, you do, I'm sorry. to
if
interrupt.
we do approve this, then all of this language in here about that being a commercial lot is null and void, right?
not necessarily null and void, but if they're amending their regulations, but yeah, essentially null and void. I mean, they could still have it in there. I think that you should make that a condition. And again, you still have time on this. The deadline for this is next Tuesday. That shared driveway is sometimes a good thing and sometimes can be used in a way that we don't necessarily want to see it used. And, you know, I would really like to have seen it built to a subdivision road because it is on tract 5A. You know, we've had these discussions. I had these discussions with Bernadette. I had these discussions with the planning board. But our subdivision regulations do allow for a shared driveway for 2 lots. How do you make the case that this driveway is for 3 lots? Because if tract 5A had no other access, i.e. if it was not on Silos Road, you could easily say, no, that's for 3. But the fact that tract 5A does have road frontage, and when they come in to request an address, the county will have to give them an address off of Silos Road, not off of that shared driveway. That's not saying that they can't use the driveway. I mean, this is saying they can't use the driveway, but who's going to police that? Where's our authority? You know, when I first came here for the county, you know, my predecessor, you know, always find your authority. I cannot find the authority that says they can't have a shared driveway. I don't like it.
Yeah, you know, I'll tell you, I'll be honest, I really see this coming back before the commission at a date down the road. The way this is set up, it will just be here before the commission again. And this is what we're trying to avoid, because we've all had to deal with
Sins of the past, sins of the father,
things of the
they come
past,
back.
and here we're not solving that problem.
I'm gonna throw out a different thought on that though. It is a public use easement, and I think that addition by the sheriff makes a lot of good sense. If somebody buys 1A for a business, something that the developer, something that the planning board hasn't envisioned, I think it's actually a plus for the community that they're coming back through the process. And at that point, that road would be built, and then the issue would be moot with the shared driveway, because it's now a county road standard road. So I would say it's good that they're coming back, rather than some kind of a blanket being applied to the lot, that it can only be used for a restaurant, for example. As far as the shared driveways, we have to address that in our regulations, because we don't have any teeth to go off of our regulations at this point.
Well, the other side that I have that is the guy on 5A, if he puts a shop on the back corner of 5A and say he's a construction guy, he's gonna drive down that driveway to get to his shop. And who's gonna tell him, no, you can't drive on that road? And then what's gonna happen is pretty soon we need to have the sheriff out, or this guy's driving on my driveway. And that's exactly what we're trying to avoid.
Exactly, yeah.
It seems to me that it would be a lot more feasible for the developer to build that road to allow for commercial access, because that's what's gonna happen with that lot. And he could get more money with that, if he could sell that lot as a commercial, he'd get more money for it if he already had the road in, than if he, well, yeah, I'll sell it to you for commercial, but you have to go through all these steps.
I'm not arguing with you, but, and the landowner has gone through all of these decisions, and this was their decision to move forward this way. If they did build that road, then, of course, with no zoning, it could be easily used commercially without any, I mean, if they went to build the road, they would probably amend their application.
But then they would go back through the process
Right.
and, you know, that, and with that commission required covenant, they could not make it a commercial lot without going through an amended subdivision process. And that would be caught, if you will, for lack of a better word, at the time of septic approval, because the sanitarian obviously would not be installing or signing off on a residential septic permit if it were going to be used for a restaurant, a gas station, a hair salon.
So what's the recourse for lot owners 5A and 2A saying, well, we bought this as residential with the understanding that this road is a shared driveway, and now all of a sudden you're coming here and telling me that you're gonna make this a commercial road through my property?
I guess
What do you mean by recourse? I mean,
Well, I mean,
What?
so can 5A and 2A say, well, now you've made this a commercial lot, so now you're taking away from the value of my property because now I have all this commercial traffic coming through my front yard. So now you're taking away from those two landowners simply because the developer didn't wanna put the road in and already have it as commercial.
yeah, I mean, I suppose that absolutely could be a case for that.
From the perspective of a commissioner though, we would hear public comment from those landowners and take that into consideration with our decision. If those landowners said, I am so happy there's a restaurant going in next to my place, or a whatever, that would be one piece of public comment. If they said, hey, this is not what I bought and I don't want this, we would take that into account. We are not obligated to grant a commercial, the ability for this to be commercial after approving the subdivision within our regulations. Correct me if I'm
Correct,
wrong.
no, and you could always hang your hat on in the interest of public health and safety.
Yeah,
That's such a strong, I mean, that means so much. In the interest of public health and safety, you could deny the application of an amended Tract 1A to become commercial and construct that road, which is another, that's still something that the developer should be aware of.
I would like to also suggest that in the covenants, like I said, they do need to be amended because of the staff report required, or the commission required covenants. I think the covenants should be amended to, off my head, I don't know what, but that if it was ever used, any of the lots were to be used commercially, they would have to come through the subdivision process. The 60-foot easement gives buyer notice, just like the last subdivision we were talking about. If there's a 60-foot easement going through your property, that's a public easement. When you purchase the lot, right there, you're getting notice that there is a 60-foot public access easement through your property. So it's really no different than doing the half roads or whatever in the future. If a landowner bought that and said, hey, there was nothing in any works with the subdivision going to the south of here, now there's going to be a busy road and possibly 100 lots that could be coming right through their place using their road. That's why, like I said, we can't do it to Grandview now. With the buyers buying at this time, they see that easement, so they have forewarned knowledge and can make that decision. So that argument would be just the same as a road to nowhere, what we called them sometimes. Because they would just go to the subdivision boundary and end. But that gives you advance notice when you purchase that lot, that there is a public easement 60 foot wide going through, which is what we have on here also.
so do you agree, I think Bernadette's suggestion makes a lot of sense. Do you think it's required and it's a good idea to have, after it says per the subdivision application, all lots shall be used for residential purposes only, and it is required to come before the commission to turn this into a commercial lot with, better language than that. But do you think it's needed when it states right here that it's for residential only, and we have it in the regs?
With that being said, it might be better to actually include it in the heading of the commissioner required covenants revocable or alterable only with the consent of the Broadwater County Commissioners through an amended subdivision process. Because all commission required covenants will have that same requirement. So it's not specific to just A, it's also applicable to A through Z. So maybe with that being said, I need to include that verbiage just in the heading of the commission required covenants, comma, through an amended subdivision process.
I like that, if you don't mind.
Okay.
And as far as you guys are concerned, I'm happy to, with that change, move forward today, or we can wait till next week and put it back on the agenda. Since we do have the extra day.
You do. That's the advantage, I think, of having that on Wednesday too.
Yeah.
It doesn't prolong it so terribly long for the developer
Yeah.
or the representative to get working gathering items.
So we're actually approving the preliminary plat with this paperwork versus this paperwork.
That is your document in your left hand that you will be signing. That's what you are approving, yes.
Okay.
But I still think it's a good idea, with that being said, even though they are amending their covenants, and I fully take them at their word, I still think you should include that as a condition of approval, that their covenants should reflect that, and, you know, maybe in a more eloquent way of putting it, but, because if for some reason they decide not to, which I highly doubt that they're, you know, I'm sure they're going to move forward doing that, you cannot come back and require that they amend those covenants. Even though those covenants don't have teeth, it's still misleading to any future lot owners, because it is contradictory to your covenants.
You know, and we keep talking about future lot owners, but, you know, what number 2 states, it says that if the declarant owns any of the lots, they may unilaterally amend this declaration without the consent of any other lot owners. So that means if these folks right here are the lot owners, they could change this.
They can change their covenants. They can't amend
Yeah.
your covenants without going through an amended subdivision process, basically coming back here.
And we're going to be, well, Bernadette said that is going to be changing because part of our approval process is going to include having that change to mirror the language in the commission-approved covenants.
Okay.
That's secondary to ours.
Yes, yours will always have stronger teeth. You have the sheriff's office and the county attorney, if you have to go higher than that, backing you on commission-required covenants. Any landowner proposed covenants, they're on their own. I mean, I hate to say that, but, you know, the county does not enforce covenants. We only enforce commission-required covenants.
Then they can change them weekly.
Yeah.
As
And it's been done,
So,
And those people really well.
I do know.
so when this comes in for final plat approval, 2, 3, 4, and 5 will all be removed
Of 2, 3, 4, 5
of their hand, of
If-
this booklet that we got.
if you include that as a condition, it absolutely must be. If you don't include it as a condition, I'm not even gonna look at it to see if it's been amended. I mean, I'll look at it, but I'm saying, you know, it won't matter.
You have no teeth.
I think it
No.
has to be.
Yeah. So if you want 2, 3, 4, 5, is that what you said?
Yeah.
Removed, you absolutely should include that as a condition of final plat approval. That way you will see it at this table in however many months when I come back to you with all of the final
I think that we
documents.
should remove 6 also, because
Yeah.
all of those have to do with the declarant having a right to override all the rest of the
I
land.
agree.
So 2, 3, 4, 5, and 6 have to be removed from their covenants.
As long as there's a reason why I mean, can you point that back to being contradictory to the commission required covenants? I don't want you to get too deep in the weeds and, you know, say, well, I don't like that they
Well,
have the power.
I guess you might have to take a look at that and see.
Okay.
Anything that says the declarant can change the use of the lot without the adjacent land.
As long as it has that language that's contradictory to the commission required covenants, you absolutely can request that change. If it's saying, you know, the declarant will only allow pink houses, you don't have any, you don't wanna remove that covenant, there's no authority for you to remove that covenant, is what I'm saying.
We would be wiser not to pick 2, 3, 4, 5, and 6. We would be wiser to say their covenants must mirror the commission
county's.
covenants. Because one, we could miss a number, 2, we could add 1 that we shouldn't be adding. So if we keep it general that it needs to mirror our language, then that applies to the entire document.
About conform to.
Conform is much better, yes.
Okay.
The other thing too, before a motion, according to 76.3608 MCA, subsection 6, I think? No, 3A6. No, 3A, sorry. Okay, so, this is something we should be doing with every single preliminary plat, is going through this, and I'll explain why in just a second, but, the impact on agriculture has been addressed in the findings of fact, and it shows that there are none. The impact on agricultural water user facilities also shows that there is no impact. The impact on local services has been addressed and mitigated by all the local services, and will be addressed in our motion. The impact to natural environment has been addressed per the findings of fact. Impact to wildlife appears to be nil. The impact to wildlife habitat is also, there's plenty around the property, so it's mitigated. And the impact to public health and safety is also being mitigated in the plan and also with our motion, intended motion. So the reason we have to do that, we had a meeting, and you know what? I'm going to share it with you when we're done, so I don't muddy the waters. But share that, because that should be done by the commission, even though it seems redundant. So are you guys ready for a motion then?
Yeah.
I will move, based on 76.3608, and our discussion, that we grant preliminary plat approval to Forest Springs Estates minor subdivisions with the requirement that all covenants from the developer reflect the commission required covenants in the findings of fact, and request of the community development director that all the language prior to commissioner required covenants include that any changes need to go through the subdivision process for approval.
Is there a second?
Second that.
Motion's been made, second. As stated, any further discussion? All in favor?
Aye.
Opposed, same. Motion carries.
So I'm glad Nicole is still here. Are you ready to move on to another thought?
In one moment, I'm sorry, I
Okay.
just want to make sure that I'm capturing this. I am ready.
So I share this because this is something that the commission, all three of us, need to learn and need to do. I'm not going to share any of the details, but Nicole and Nicole and Julie, years ago, were asked to be deposed for a lawsuit on the subdivision. I was asked to sit in on the meeting. The attorney, in talking about deposing Nicole and Julie, was going through everything that they do, and I said, well, what about the commission? Are you going to depose us? He said, no, you guys don't get deposed. Everything, your entire defense is in your vote and your discussion for those findings of fact. If you didn't go through each of those pieces that's required in MCA, doesn't matter. You can be deposed up, one side and down the other, but if you didn't do it when you made your vote, it essentially says it didn't get done. He said, you need to go through each one of those in detail, and we have done that in the findings of fact, but if we don't verbally say we acknowledge that this document reflects MCA, it didn't get done.
Christine, didn't we talk about doing a little checklist for ourselves?
That's right here.
Yeah, so that we do that every time. So
I would we each get one of these.
Yeah,
We'll be getting another one here shortly.
yeah.
Nicole gets 5, one for Daryl, one for Mike, one for me, and this should come with you every single subdivision we review. And
Right.
that statute should be followed by at least one of us, if not all 3 of us.
As part of your, sorry.
What's that?
That number again.
763608.
As part of your findings of fact and order packet, I could easily cut and paste that from MCA with a little checkbox by it and include that in your findings of fact and order report or in the front of the subdivision application. Because I do think that's good practice, because, yeah, I do remember that deposition.
Yeah,
It's not very fun.
no. And I don't think it'd be appropriate for you to put together a checklist for us,
Okay.
because if we don't follow what you told us to do and we miss something, that's on us. It shouldn't be something where we can blame you for not doing our job. So we need to have the checklist, maybe make one of our own. I used to have one in a, that I brought to every subdivision.
Well, that's what I'm talking about, just
Yep.
something.
You can put together
Our
one for
own
yourself.
little guideline that we follow.
Yeah, yeah. So I asked you to stay because I had a phone call from Morris and Merrily yesterday, and they said that our highway from town to the silos is on the list for 4-lane construction. That affects what we've talked about here, and what they said is, you guys need to get on the list to maybe have a walking path added to the bridge.
Okay.
Since they're doing the construction anyway, they've actually had a record of doing that. Since you are working with the rec board,
Mhm.
would you mind, I'd be happy to attend the next meeting if
Yeah,
I
absolutely.
can and share what those guys talked about. We had a meeting years ago with, and I think we've talked about that, but trying to get some kind of a walking path added to our bridge because it is so unsafe, it's so narrow. And MDT said you have to have a reason for it. Well, we did that. And now that they've got the construction project, maybe that's an opportunity.
Okay,
Yeah,
perfect. I will follow up on that.
thank you. There was another, oh, did you do the zoning notice? We're gonna have that on the 15th? I think the 14th is Monday, and it's a holiday. Can't be done any later.
I didn't post any notices other than the one for next Friday.
Okay,
That's the only notice I've posted.
so I think today it has to go in for this one.
Oh dang, okay.
Which we should be okay, because I think she says 2. But let's do it as soon as possible and get that in, because it says no later than the 16th.
Okay, I was reading that as posted, when I saw that, posted no later than the 16th.
Oh, is that what it says?
I don't know. I will look into it. I
Okay.
did read this.
Okay, I
And
know
I'm
you
sorry,
did.
I was looking at it because it's to begin the 30-day protest period, and then the county commissioners will be meeting on the 18th. So that's the way I interpreted it, not that the meeting for this, I better call Janet.
Yeah, zoning notice.
Mm-hmm.
My guess is it needs to go in the paper for the second reading, October 15th,
Okay,
and then start the 30-day process for this one.
okay.
So I would suggest doing the notice first, then call Janet to
Okay.
double check.
So
You can
just-
always pull it, but let's make sure we get it in.
Perfect, okay. I
Yeah.
don't know if it's already 12:30. We have only until noon, don't we? Or is it 2?
I thought it was 2, but maybe try and get it in if you can.
Okay, all right,
Otherwise, we'll see what we have to do
perfect.
for the 15th, not the 16th. if
For the
that's
15th,
okay.
not the 16th.
Yeah.
Okay.
Okay. Yeah. Thank you.
You're welcome. Was that everything? You said you had 2 things for me?
That was
Those
it,
the 2,
the road,
right?
the bridge, and that.
Okay, perfect.
All right.
And so you are going to add Lake Vista Lot 5 minor to Monday's agenda?
Yes,
Okay.
yes. Just that one.
I'm going to make this amendment, and I will make sure that you all have a copy, and then I will have you sign it. I don't want
Okay.
you to sign it until I make the amendment of those 2 conditions.
I see all your chicken scratch, it just
Yep.
doesn't look professional.
Nope, it really doesn't.
I do want to say just one other thing. Wherever you guys decide to land on that claim is fine. And each commissioner needs to make their own decision. But To reduce this to, I don't like when, is absolutely wrong and inappropriate. And you guys know from our experience working together, I pull a number of claims. And frankly, we should each three be pulling more because some claims have gotten through that should not have. We had a closed-door meeting. We had a closed-door meeting with the board that allowed a claim to go through that shouldn't have. We had a claim go through that where a person violated the code of ethics. And as much as that was supposed to come to a meeting, it actually got signed instead and passed through. So we three need to be much more diligent on the claims. It may really stink because it's a lot easier to just be a yes stamp. But just because a claim comes before us doesn't mean we're obligated to sign it. Our obligation is making sure that every decision is equitable, and we sometimes make the hard calls of saying, I question this expense. I have questioned a number of expenses, and not all of them are wins. So that was an unfair statement on his part. I'm not going to influence your votes in any way on that. The other thing is Daryl, I would request in the future, when I do put a note on a claim, which I've done often, let me know that you gave authority. I
didn't give authority. He kind of misspoke, didn't give authority. I said I didn't think there'd be a problem with it. And where I probably made my mistake is not talking to you guys about it, but I just didn't think there'd be a problem with doing something like that. So I guess I learned something from that, and we'll just stop right there.
That's fine, it's just,
Okay?
I put the note on, just shoot me an email
Yeah.
so that I know.
I didn't actually see it because it went in the mailbox.
You're supposed to be going through the mailbox
Well,
before every meeting.
Or don't tell me what I'm supposed to be doing.
Those are commission documents, you
I
should
go
be
through there, and
blind.
I just didn't catch it, okay? So let's just stop. Stop before we go any further, please.
You know what, I have a
I'm
job
gone.
to do,
I'm gone.
Daryl. You're out of line.
You're out of line.
Holy cow. You know, we three have a job to do here, not just one of us.